Good morning, Your Honors.
Morning. Whenever you're ready, counsel.
Thank you, Your Honor. Thank you, Your Honor. Good morning. May it please the court. My name is Jason Lambert, and I appear on behalf of the appellant, Robert Vance. Judge Kelly, if I could reserve 5 minutes for rebuttal.
Yes, sir. You got it.
Thank you. Mr. Vance respectfully requests that this court reverse his convictions for aggravated battery for two reasons. First, the trial court should have granted Mr. Vance's motion for judgment of acquittal at the close of the state's case because the state failed to present evidence of Mr. Vance's specific intent to harm the two motorcyclists with his vehicle. And second, the trial court erred, in one case fundamentally so, when it declined to instruct the jury on Mr. Vance's affirmative defenses of self-defense by justifiable use of force and necessity. Therefore, Mr. Vance requests that this court reverse his convictions for aggravated battery, or at a minimum remand for a new trial where the jury can consider the requested affirmative defenses. Turning to my first argument, the trial court should have granted the judgment, the motion for judgment of acquittal at the close of the state's case because the state failed to present sufficient evidence of Mr. Vance's specific intent to harm the two motorcyclists here. The trial court, actually in denying the motion, seemed to equate the mere fact of injury or impact between Mr. Vance's vehicle and the motorcycles with intent. And that's not actually what the law allows or what the law permits under these circumstances. The only evidence presented by the court or to the trial court was obviously the video that Your Honors have seen that's in the record, and then also the testimony of several of the motorcyclists, including Mr. Calderazzo, whose only testimony in the record on page 202 was that after the interaction and the altercation between the motorcyclist and Mr. Vance, he saw Mr. Vance turn his wheels to the right and knew that he was going to come into his lane. There's no testimony that he knew Mr. Vance was going to hit his vehicle or that he knew Mr. Vance was going to aim at him or try to run him over. It was just that Mr. Vance was going to enter the lane of traffic. And that's not sufficient to establish the specific intent required to support the convictions for aggravated battery. And there's two cases that I'd like to bring to the court's attention on this that support the argument that the mere fact of contact doesn't supply the requisite intent. The first of those is a case decided by this court in 2003, Beard versus State, which involved a circumstance where a man was at a party. He stabbed another man there and then ran out of the house and got into his car and started to back down the driveway. While he was doing that, people from the party who had been in the house were jumping on his car, trying to get him to stop. And two other people who had come out of the house were ultimately hit by his car as he was trying to exit down the driveway. This court reversed the aggravated battery convictions on those two people there, finding that under those circumstances, the driver of the vehicle was just trying to get himself out of a terrible situation, that there was no intent to run over the two people who he actually hit in the driveway, but also that there was no intent for him to hit or injure any of the other people who had jumped onto his car or were trying to make him stop leaving the house. And that's a really similar situation to what we have here. The testimony in the record from the motorcyclists themselves before the state closed its case is that at the record on page 232 and 238, that the motorcyclists were yelling at Mr. Vance. In fact, Devin Grubb at page 258 of the record testifies that the motorcyclists were the one who started yelling at Mr. Vance first. Then Mr. Calderazzo, who was actually one of the injured parties, testified on page 232 and 233 of the record that he grabbed a 2.5 to 3 foot long leather strap off his motorcycle and used it to hit Mr. Vance's car. So Mr. Vance later on would testify that he was scared, but certainly under the circumstances there, that conduct mirrors the conduct that was going on in Beard versus State. Mr. Vance simply accelerated away to try to get out of that situation where he was boxed in and where the motorcyclists were around him and yelling at him and beating his car. And in the process, he accidentally ran into the motorcycle holding Mr. Calderazzo and Ms. Milinkovic. So under those circumstances and under this court's own decision in Beard versus State, that doesn't rise to the level of establishing the specific intent necessary to support the two convictions for aggravated battery. One is to Mr. Calderazzo and one is to Ms. Milinkovic. Now, moving to my second point, the trial court here did also err, assuming for the sake of argument that the trial court correctly denied the motion for judgment of acquittal. The trial court still should have allowed for a jury instruction, one of the two at least jury instructions requested by Mr. Vance as to aggravated battery. If you take a look at the jury instructions that were ultimately approved in the record as to aggravated battery, there are no affirmative defenses that the jury was instructed on. And the reason that this is an issue is because the trial court, in failing to allow
counsel, as to the justifiable use of deadly force, the defense attorney below agreed that that was not an appropriate instruction to give because the defense was that this was an accident, and so therefore that particular instruction would not be relevant given the posture of the case.
Well, I would disagree.
So we would have to find that there's fundamental error, or?
Yes, Your Honor, and I do agree.
I mean, not only was it not preserved, it was affirmatively disavowed by counsel below.
Well, I think it was, yes, Your Honor, I do agree that in the record, counsel for the defendant does state that he agrees with the trial court that that defense doesn't come in because of the testimony regarding intent. But in the
excuse me, counsel, why isn't that a waiver?
Well, it's not a waiver for two reasons. It's still a fundamental error that actually denied.
Well, you can waive it. You can waive that. If you affirmatively agree, you've waived it. So you don't even get to fundamental error. So I want to know why it's not a waiver.
Well, it's not a waiver here because if you look at the greater context of the trial, the judge at the beginning of the case and then at the middle of the case had already made multiple rulings on this particular issue, stating that the trial judge did not believe that there was any self-defense here, that she didn't believe that there was sufficient evidence of that, and that she didn't believe that there was, and that she believed that the testimony regarding intent removed that from the case. And so at that point in time, the defense attorney is simply going along with the rulings that the trial court has already made, both during the argument on the judgment of acquittal and then prior to the jury instructions. In fact, there's even an argument in the middle of the motion for judgment of acquittal where defense counsel starts to try and argue the issue that the trial court had raised regarding the self-defense instruction and tries to, notify the court that, we're not there yet. We're still on the motion for judgment of acquittal. And the court says, no, I've moved on from the judgment of acquittal. We're discussing the self-defense piece now. And so that's how I believe it was preserved. And then at the end, when the trial judge and the state attorney's office state that, this is no longer applicable because there's no intent, then the defense attorney does go along with it. And so that, one, in the greater context, that's why I believe there's not a waiver here. But two, because it's the trial court that brings it up and goes with it, that's why I believe it still becomes a fundamental error, because the only defenses here that were raised by Mr. Vance all come from this sort of nucleus of facts that he felt boxed in, he felt scared, he was worried about what might happen, worried if somebody might have a gun, worried that the only way that he was going to get out of there was driving away like this.
But this particular defense involves whether or not a reasonable person would think that the use of deadly force was necessary. In other words, it's tantamount to admitting that he took the car and ran over somebody because he felt threatened. He felt that his own life was in jeopardy. So therefore he's justified in responding in like kind. But that's not what he's saying at all. He's saying, I didn't mean to hit anybody. I just thought I had an opening and thought I could get through it. And I just wanted to get out of there. I wasn't trying to hit somebody with my car. It doesn't apply to the facts.
Well, it does, Your Honor. While generally the general rule is that testimony from a defendant that they lack the intent would preclude a defense of either necessity or self-defense. There is an exception for where under the testimony that was given, the jury could
So
find.
we would, if we reversed on this, we would have to write an opinion saying that this was a fundamental error by this judge, despite the fact that the defense had disavowed the relevancy of this defense.
Well, that would
The
only
whole point of preservation, the whole point of having the discussion below is so that the trial court can understand what's being claimed and whether or not it's applicable or not, and not find itself in a posture like this one where the court's being second guessed for something that was conceded by counsel.
Well, notwithstanding the argument that happened during the motion for judgment of acquittal, that only applies to the defense of self-defense. The other defense that was denied here was the defense of necessity. And that one there was argument on below. And that one, the trial court also.
So are you abandoning the first one and now we're moving on to the second one?
No, Your Honor. I just wanted to make clear before my time runs out. I just wanted to make clear that both of them were denied.
I know this. I understand the necessity one was requested. That's different, and it was in fact given. It was given as to the lessers, right? Correct?
It was not, Your Honor. It was not given at all with respect to the aggravated battery claims. It was given with respect to.
No, that's not what I'm saying. It was given with respect to the reckless claim.
Yes, but that was count 3. There was no affirmative defense given as to count 1 or count 2, which were the 2 aggravated battery claims.
Right.
So that's why the trial court error. That's the error with respect to the necessity defense. The trial court on the testimony given completely failed to give any sort of defensive instruction as to the aggravated battery, despite the fact that there was significant testimony by both the motorcyclists, all 4 of them, and Mr. Vance, that the motorcyclist instigated the initial interaction between the parties, that Mr. Vance felt threatened, that the motorcyclist, told him to get out of his car, that they hit his car with a 3-foot whip. Under those circumstances, the jury should have been given an opportunity to address that in making its decision, and it was totally deprived of any opportunity to do that with respect to the 2 aggravated battery accounts. That's one, why it was an error for the judge to deny the necessity defense, but that also illustrates the fundamental error relating to the first self-defense by justifiable force. In fact, in Vasquez v. State, the 4th DCA in 1987 addressed this issue and stated that the omission of an instruction on self-defense where there was evidence in support of such a defense theory and where such an instruction was requested is logically fundamental error, and that it's important for the jury be aware that self-defense is something that it should consider in its deliberations whenever there is any evidence in that direction. And in that case, the court reversed a conviction for aggravated battery because there had been no self-defense instruction given. With respect, just to touch briefly back on the option here of waiver, if you look in the transcript on page, I believe it's 494, the self-defense instruction was initially, it's expressly stated by the state that it was initially included in the request, in the proposed jury instructions. And then, yes, the defense counsel said that, yeah, they weren't going to include it, but there isn't debate or discussion about it. That happened earlier during the motion for judgment of acquittal. The defense attorney there is simply acknowledging what happened before and then moving along. And so, again, I would say that that is very much akin to if the defense counsel hadn't said anything, if he had remained silent, if the judge had just said, I understand there's a self-defense instruction here, we're not going to allow that, we're moving on to the necessity one, and counsel says nothing. That to me is very similar to what happened here, where there's just a very minimal interaction. And it's fundamental error because the court is pronouncing, the trial court is pronouncing and relying on an improper standard here. And I know my time
Mr.
is
Lambert, I want to go back to your motion for judgment of acquittal. You moved off of that pretty quickly and I didn't get a chance to ask you a question. You're relying on Beard and like WEP, and those cases use the reasonable hypothesis of innocence analysis for circumstantial evidence, which I'm sure you know is no longer good law. So how would you make your argument? I mean, you're relying heavily on Beard and WEP, but I don't see how they're good law anymore.
Well, we're not relying on the reasonable hypothesis, the reasonable hypothesis.
Well, that's what they relied on.
Well, but the facts there are still analogous, and the analysis actually that the court conducts, the court does conduct the reasonable hypothesis analysis there, but the court also is simply looking at what happened there under the circumstances, and under that factual scenario, the court determines that the evidence there didn't support intent. And I see that my initial 15 minutes is up. Can I have just
Yes.
answer your question? Thank you.
Yeah, that's fine. Thank you.
Not a problem. Thank you.
All right. Mr. Tannen?
Good morning, Your Honors. May it please the court, my name is Jonathan Tannen, representing the state of Florida, and the state is requesting that the judgment and sentence be affirmed. On the first issue, the denial of the motion for judgment of acquittal, the appellant is arguing that the motion should have been granted on the issue of intent. The law is very clear that intent has to be determined from the surrounding circumstances and is almost never a basis for a motion for judgment of acquittal. And of course, the standard for a motion for judgment of acquittal is competent substantial evidence with all reasonable inferences being taken in favor of the state. In this case, there was significant evidence and competent substantial evidence from which the jury could determine that Mr. Vance intentionally struck the motorcycle with his car. We have the testimony regarding what was happening immediately before the collision, which was that Mr. Vance was in an argument with the motorcyclists. He had previously cut them off in traffic and almost run one of them off the road. And then when they all pulled up to the next traffic light, an argument began regarding the initial cutoff. The motorcyclists were yelling at Mr. Vance, but Mr. Vance was also yelling and screaming at the motorcyclists. He was telling them that they were crazy. He was gesturing at them with his middle finger. He was cursing at them. And then, which the part of the events that are captured on the video, Mr. Vance backs up his car 3 to 4 feet, turns to the right, and accelerates directly into the motorcycle with Mr. Calderazzo and Ms. Milinkovic sitting on it. He then drives over the motorcycle, crushes part of it, and speeds away from the scene. There was testimony that the light had turned green at that point, and that if his intent had been to leave the scene, he could have simply driven forward. The state would submit that all of this evidence put together was sufficient for the jury to determine that Mr. Vance did intentionally hit the motorcycle with his car. And I think it's also important to point out that in the video, now Mr. Vance's defense during the defense's case in chief when he testified was that he accidentally hit the motorcycle. And that was, I understand that was his defense, but in the video, the car clearly appears to be aiming directly at the motorcycle. It doesn't just graze it when it goes around it, or it doesn't just graze the motorcycle trying to go around it. You see the car pointed directly at the motorcycle and then drive straight into it. So under these facts, the state would submit that the motion for judgment of acquittal was correctly denied. As far as Beard versus State and WEP versus State, Judge Kelly, I think you're correct that at the time those cases were decided, the reasonable hypothesis of innocence standard was still in effect, which of course it isn't any longer. In addition, the facts of those cases are very different from this case. In Beard, the testimony was that the person had stabbed someone at a party and had gotten into his car and was backing out of a driveway, but the two victims apparently stepped into the path of the car while it was backing out and were struck. This is not a case where the victims stepped into the path of the car. This is a case where Mr. Vance aimed his car at the victims and accelerated into them. So I think the facts of Beard are really not applicable here. And in WEP, the facts were that the defendant, who was a juvenile, was trying to flee some people who were trying to attack him. I believe that part of the case wasn't in dispute. And he had an encounter with a police officer who tried to get him to stop, and the police officer somehow became entangled in the car's seatbelt and was dragged for a certain distance as the defendant was driving off. And the court, under those circumstances, found that there was insufficient evidence that the defendant intended for that to happen. Again, that's very different from this case. And the court in WEP actually specifically noted, with respect to the charge of aggravated battery with a deadly weapon, that there was no evidence that the defendant had done something like, for example, aimed his car at the police officer. And that's exactly what Mr. Vance did here. So under these facts, the trial court did correctly deny the motion for judgment of acquittal. On the issue of the jury instructions, the self-defense jury instruction was clearly waived based on the record. While he was on the witness stand on cross-examination, Mr. Vance testified, well, he initially testified on direct examination that he hit the car accidentally he hit the motorcycle accidentally while he was trying to go around it. And on cross-examination, the prosecutor asked him, so this was just an accident. You weren't acting in self-defense by hitting the car. And Mr. Vance said yes. Subsequently, during the jury charge conference, the trial court stated that in light of Mr. Vance's testimony, self-defense was no longer applicable to the case. And defense counsel agreed with that statement and didn't make any arguments in support of keeping the self-defense instruction. And there's no indication in the record that counsel had any intent of arguing self-defense as a defense in the case. So the state would submit that this issue is clearly waived based on the record. And as far as fundamental error, if the court were to reach the fundamental error beyond the waiver issue, the Florida Supreme Court has held that failing to give an affirmative defense, which does not go to the elements of the offense, is not fundamental error. Fundamental error only occurs where there's an error of such significance that the conviction could not have been obtained except for the error, and where we're talking about an instruction on an affirmative defense, that is not the case. The state would also argue that even if we were reviewing the issue if the issue had been preserved, the trial court would have correctly refused to give the instruction. In order to be entitled to self-defense, the defendant has to have been presented with, has to have been a reasonable person in the defendant's position would have had to believe the action was necessary to avoid death or great bodily harm. In this case, Mr. Vance was inside a car arguing with people who were outside the car. There was testimony that Mr. Calderazzo struck the car with a leather strap, which he said he did to get Mr. Vance's attention and to, drive home that what he did was not safe for motorcyclists. But there was no testimony that anyone tried to break into the car. There was no testimony that anyone displayed a gun or a deadly weapon. And under these circumstances, Mr. Vance was not justified in using deadly force. And I think it's important to note that there is no dispute here that what Mr. Vance did was deadly force. He aimed a car at two people on a motorcycle and accelerated into them. For legal purposes, it's equivalent to Mr. Vance having pulled out a gun and shot at them. And under these facts, there was simply nothing that would have justified Mr. Vance in taking that action of using deadly force. So the state would submit that for multiple reasons, this issue is not a ground for reversal on appeal. The final issue is the necessity and duress instruction. That instruction was properly denied for the same reason why self-defense wouldn't have been warranted. There had to have been some evidence that the defendant was facing an imminent threat of death or serious bodily injury. And again, there was no evidence of that. The trial court noted during the discussion on that instruction that this might be a different case if someone had displayed a gun at Mr. Vance, but there was no evidence of that. In fact, Mr. Vance said during his testimony that he tried to drive away and he was afraid because he didn't know what would happen. He said, people are getting shot all the time in road rage incidents. I didn't know if he had a gun and I wasn't going to wait to find out. And the trial court correctly pointed out that given that testimony, there was simply insufficient evidence that a necessity defense applied to the charge of aggravated battery. The state would also submit that even if that had been error, any error was harmless on the face of the record. Judge Black, you did point out that the instruction wasn't given on the offense of aggravated battery, but it was given on the lesser included offenses on counts 1 and 2 for reckless driving. And it was also given on the charge of fleeing or eluding. And the defense's argument with respect to why that defense applied to fleeing and eluding was exactly the same as aggravated battery. It was that the defendant was afraid of the motorcyclists and he believed he needed to flee the scene in order to get away. The jury did not believe that with respect to the charge of fleeing and eluding. They also didn't believe Mr. Vance's testimony that he hit the motorcycle unintentionally. And the state would submit that under these facts, given the jury's findings, there's no reasonable possibility that even if that instruction had also been given for aggravated battery, that the outcome of the case would have been any different. If the court has no further questions, I will request that the judgment and sentence be affirmed, and I will rely on the answer brief for any further arguments. Thank you.
Thank you. Mr. Lambert?
Yes, thank you, Your Honor. Just a couple of points on rebuttal. Beginning with the last point that the state just made there, the fact of the matter is that they can't hypothesize at this point in time as to what the jury would have done with a properly given necessity instruction or a properly given self-defense instruction, because the jury was never given that opportunity. There was significant testimony at the trial by both the motorcyclist and Mr. Vance about the total interaction between the parties, illustrating that the motorcyclists were the initial aggressors, and discussing everything that happened between them. And under those circumstances, the jury was completely deprived of any opportunity to address that in a defensive posture as to the aggravated battery claims. And that is what demonstrates not only the error in the trial court failing to give that instruction as to necessity, but also demonstrates the fundamental error, because it deprived Mr. Vance of the opportunity to have that testimony and that evidence taken into account as a counterbalance and an offset to the aggravated battery claims. So that is how this rises to that level. And second, I'd like to point out also the state uses the example of drawing a gun and how that would have changed or modified the case. And actually, there's an opinion from this court in 1996, Stewart versus State, where there were two vehicles. One of them were driving very erratically as one of the occupants of one of the vehicles gets out and is approaching the other one in a threatening manner and appearing to be very angry at them. The occupant of the other vehicle holds up his unloaded firearm and waves it around in an attempt to scare away the other person. And this court ultimately reverses that gentleman's conviction of either aggravated assault and or aggravated battery, finding that the trial court there erred in failing to give a instruction on that justifiable show of force as a defensive measure and as self-defense. And so here we have a similar circumstance. We have Mr. Vance, who's testified that he's scared, that his car is being whipped with what's essentially a cat of nine tails. In the record at page 234, Mr. Calderazzo testifies that it's made of leather straps that are separated at the bottom 10 inches or so. This is not a tassel like is on your kid's bicycle. This is a weapon in every sense of the word. And it's being used to hit his vehicle, and it terrifies him. And so he uses that to get away from there. And so that illustrates all of that. The jury had no mechanism for how to deal with that when it went back to deliberations, because there was no necessity defense given and there was no self-defense jury instruction given. And so under those circumstances, Mr. Vance is absolutely entitled to, at a minimum, a new trial for a jury to take that into account and have an opportunity to decide if those defenses would have ameliorated or taken care of the aggravated battery claims. And so under those circumstances, we respectfully request that the court, again, reverse the convictions, but at a minimum, remand for a new trial where these defenses can be presented. Thank you.
Thank you. Thank you both. Right. Our next case is going to be Velasquez versus Logistic USA.